Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about a case that got everyone all spun up last couple days in the exosphere. Had to do with the three-judge panel of the Seventh Circuit finding that short barrel rifles do not constitute arms as contemplated by the Second Amendment. Had a lot of people freaking out. I've had an opportunity to go through the opinion. Certainly not going to stick up for the court's reasoning here. However, I think that the decision or who they found in favor of could have been done quite easily. And in some ways, this three-judge panel just decided to kind of play pile on the plaintiffs here. So today, let's spend a few minutes. Let's slow it down. Let's break it all down. And let's talk about the court that just ruled SBRs are not arms. Okay, America, we are going to talk about an old case, a new case, and the case we're also talking about, and we're going to see how they all interconnect, because they do here. What we're talking about today, the case today, is United States of America v. Rush. This is a challenge to 26 United States Code section 5861 sub D, which actually makes the possession of a short barrel rifle a felony unless it is appropriately and properly registered as an NFA item. The defendant here obviously was found in possession of a short barrel rifle, which was not registered with the NFA, and away we go. Sentence, by the way, was 30 months. Now, he had argued at the district court level that the law was unconstitutional. The district court relied on the old case that we've talked about here before of United States v. Miller, which of course is a case that dealt with short barrel shotguns, but also challenged the constitutionality of the National Firearms Act. Now, the district court had nothing of it. He entered a conditional plea, got sentenced to 30 months. Then appealed to a three-judge panel before the Seventh Circuit, who frames the issue in this case as follows. The single issue on appeal is whether Section 5861D is facially constitutional. If it is not, Rush's indictment must be dismissed. Okay, so this deals with a constitutional challenge to the NFA, which was the exact same issue that was decided in United States v. Miller way back in 1939. The only difference is it dealt with the unlawful possession of a short barrel shotgun in Miller. Here we're dealing with a short barrel rifle. Now, we can all agree that Miller was decided pre-Bruin. And clearly, the Bruin court has set forth an entirely new framework for how we're going to analyze the constitutionality of gun control regulations. Does that mean that Miller has been implicitly overruled? The answer to that is no, it doesn't. Rush asserts that early Supreme Court precedent, United States v. Miller, does not control, and that Section 5861 cannot pass constitutional muster under a post-Bruin analysis. We first address the question of whether Miller applies. Next, we turn to the related question of whether Miller is incompatible with Bruin. But you see, here's the deal. If the court determines that Miller applies, that Miller is good law, well, then the NFA is constitutional and Rush loses. And guess what? That's exactly what the Seventh Circuit three-judge panel found. But then they decided to engage in an act of piling it on, rubbing your nose in it, spiking the football, whatever other metaphor you want to come up with. And that's how they came to these otherwise rather ludicrous, however consistent conclusions amongst the Seventh Circuit. You see, because even though there is a possibility that the new Bruin framework would render the rulings of Miller useless and or obsolete and therefore overrule it, there is no court that's ever actually made that finding. And while we could all sit there and try to connect the dots, honestly, when it comes to Supreme Court precedent, you need a little bit more than just connecting the dots. And as the defendants pointed out here, the government points out that a court of appeals must follow Supreme Court precedent that has a direct application in a case, even if that precedent appears to rest on reasons rejected in some other line of decisions. We have recently reiterated this very principle. In United States v. White, we explained the Supreme Court has instructed us to resist invitations to find its decisions overruled by implication. Okay, so I want you to remember that terminology, overruled by implication, because the Supreme Court has cautioned, and obviously when you're dealing with a three-judge panel who really does not want to rule in favor of the plaintiff here, the easiest out to this whole case is just to say the following. Miller has direct application to this case, and we therefore follow it. And then the court went on to further articulate. Rush argues that Bruin compels us to find the licensing and taxing requirements of Section 5861 violate the Second Amendment. Bruin's holding, however, was not so expansive as to overrule Miller, nor does the test laid out in Bruin call into question Miller's core holding or continued validity. And honestly, the court could have ended the opinion there. But for whatever reason, they want to say it's the rule of completeness. They then went through a Second Amendment Bruin-like analysis. Number one, does the plain text of the Second Amendment cover this activity? Which, by the way, their answer was, no, it does not. And that's where you saw this quote come out, and it was, again, burning up Exosphere for a day or two. In any event, we decline to make a step one finding that short-barreled rifles are arms protected by the Second Amendment's text, at least not on this occasion under the theories presented by Rush. The record does not show such firearms are commonly used by ordinary law-abiding citizens for a lawful purpose like self-defense. And this is exactly what you're going to see when courts want to just absolutely stick it to the plaintiff here. They're going to say, hey, Second Amendment doesn't even apply, and one of the reasons we can't make that finding is you didn't produce an adequate record, and they just kind of record their way out of it. But the court had already set this up by stating, thus, this court, post-Bruin, acknowledged the Supreme Court's recognition that short-barreled shotguns fall on the constitutionally unprotected side of the bearable arms line because they are not in common use for a lawful purpose, which at its core is self-defense. And then, of course, the case they cite to is a case from their own circuit, which is Beavis versus City of Naperville. So am I defending this ruling? Absolutely not. It's ludicrous on all levels, except perhaps for one. Because clearly, and again, this could have something to do with the types of arguments that plaintiff's counsel raised on behalf of Rush. But here's the deal. We don't get to just overrule Supreme Court precedent through implication. And yes, there is no doubt that the constitutional analytical framework has changed since the time that Miller was decided. But that does not in and of itself, standing alone, overrule Miller, and therefore the court could have stopped the opinion at the very moment that they found that Miller was applicable. The only reason that we continue to talk about all the other stuff is, well, that's just the three-judge panel of the Seventh Circuit absolutely throwing a middle finger at you and the Second Amendment and rubbing your nose in it. You know, perhaps one of the most interesting things is if you go back and you take a look at some of the other cases that were in front of the Seventh Circuit pre-Bruin, when there was that old two-part analysis, the court was routinely making findings that these arms were, in fact, protected by the Second Amendment, but upon the two-part balancing test that they could engage in at that point, they believed that the societal needs outweighed the individual infringements, okay? But now that they have a new analytical framework, what do they suddenly say? Oh, now the Second Amendment does not even apply. That, my friends, is the Seventh Circuit, and when this matter is appealed to a full en banc panel, why nobody should expect any kind of a different outcome. Okay, the case once again is United States of America v. Rush. We'll link up the ruling down below so that you can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video that we should be doing around here, cool, we want to hear all about it. Go ahead and click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do all that, it's right down there in the description box. And then finally, and most importantly, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.